right, well, it's 4 o'clock and we'll go ahead and get a start, even though several people are just piling into this waiting room as we speak. Good afternoon, good early evening. My name is Megan Johnson. I am the Vice President of the Board of Directors of the Oregon Crime Victims Law Center. And today is our Access to Justice CLE. Thank you so much for the 260 people that have signed up and the several of you that have donated to our little gem of a nonprofit. If you haven't heard of the Oregon Crime Victims Law Center, well, you're going to now. You're going to hear about them now. We, as I said, are an amazing nonprofit that provides free legal services to crime victims. Some of the things that we do, we assert legal rights for crime victims in criminal cases, provide legal representation to victims of domestic and sexual violence, elder abuse, and stalking. Social support services are provided to crime victims. And as exemplified by today, we conduct trainings regarding crime victims' rights. And tonight's training, or this evening's training, it emphasizes traditionally marginalized populations, specifically the undocumented crime victims, and trying to increase our collective ability to support and represent this underserved population. We have a panel of experts today, and I'm so excited that they've about this training that they've developed. I'll introduce them briefly. Steve Mila is an attorney with Mila Law. He works out in Beaverton in Washington County. He's a former prosecutor. He prosecuted in Montgomery County, Maryland. He opened his practice in Washington County in 2004, and he represented individuals almost exclusively in personal injury litigation since that time. A large percentage of Steve's clients are from Spanish-speaking communities. He's happily married with 3 daughters. He enjoys traveling with his family in all manner of sports, but generally avoids the outdoors, which I don't think we're allowed to say when we live in the Pacific Northwest, but that's okay. Steve, you said it, I'll let you say it. Next, I'll introduce Rosemary Brewer. She's the executive director of the Oregon Crime Victims Law Center, which is, again, a nonprofit that provides free legal representation to crime victims throughout Oregon. She manages the daily operations of the center, including supervision of a staff of 6, including 4 other attorneys. She also assists victims in asserting their rights throughout the criminal justice process, including in pretrial and post-conviction proceedings. OCVLC also assists victims with representation in contested restraining order hearings, provides advocacy to crime victims. She regularly provides training and technical assistance to prosecutors, private attorneys, and advocates throughout the state on various victim rights issues. Prior to coming to OCVLC, Rosemary was an assistant state's attorney in Baltimore, Maryland. So we've got 2 Maryland expats here on our panel today. She led an innovative felony drug diversion court and worked in the collateral unit, which handled felony probation violations. She was also an assistant district attorney in Atlanta in the felony trial division. There, she handled a large number of cases, including domestic violence, child abuse, rape, and homicide. She's worked with crime victims or crime victims her entire career and is now dedicated to seeing crime victims' rights recognized and enforced throughout the state of Oregon. I'd also like to introduce Sarah Purse. She's the Assistant Director and Rural Program Coordinator for Catholic Charities Immigration Legal Services. She's been working as an immigration attorney since 2009. Her work focuses primarily on representing immigrant survivors of domestic violence, sexual assault, and human trafficking. She got her undergraduate degree from Western Washington University and graduated from the American University Washington College of Law in 2009. She is a member of many different associations and victims' rights subcommittees, including the Oregon DOJ Labor Trafficking Task Force, and is a member of the Oregon Foreign-Born Human Trafficking Task Force. Sean Rydell is a native of Long Valley, New Jersey. He entered the Marine Corps Officer Candidate School in Quantico, Virginia in June of 1994. He graduated as second lieutenant in the Marine Corps 12 weeks later. He left active duty Marine Corps in June of 1998 and started working as a deputy district attorney with the Multnomah County DA's office in June of 2002. While there, he prosecuted misdemeanor offenses, felony property crimes, domestic violence crimes, sexual assault, homicide, aggravated murders, gun crimes, financial fraud, and gang crimes. He left the Multnomah County DA's office in June of 2009 to serve as a prosecutor with the Oregon DOJ. He worked in the criminal justice division there for 2 years, the civil litigation for a year, and then started his own practice in 2012. He, during that time period between 2002 and 12, he was recalled twice to active duty by the Marine Corps to serve in Iraq as a combat engineer officer in support of Operation Iraq Freedom. He now focuses his practice on representing victims of crimes, public employees, and veterans. His practice touches several areas of law, including plaintiff personal injury, labor disputes, internal affairs, veterans preference in public employment, whistleblower protections, and civil rights litigation. He was elected to the board of the NCVLI in May of 2019. He has remained active in the Marine Corps after his deployments. Last but not least, I'd like to introduce Kara Brooks. She's a deputy district attorney at the Clackamas County DA's office. As a prosecutor, she's handled hundreds of criminal matters and taken nearly 100 cases to trial, including major person crimes, sexual assaults, and murder. Her specialty and her reputation of expertise is in the area of prosecuting domestic violence offenders. She, as part of this work, she works closely with crime victims, including many who are underserved or especially vulnerable. Giving these victims a voice in the criminal justice system and working to obtain justice is the most rewarding part of her work. She graduated with honors from Lewis and Clark Law School in 2013. The breadth and depth of their experience is tremendous. I could go on, but I'm already running 2 minutes over. We're going to jump right into our panel of presenters. In your written materials was an agenda, and at the top on page 2 of the agenda, the way we're going to structure our CLE today is by working through 2 case studies, and those case studies are on pages 2 and 3 of your agenda. If you hadn't had a chance to review them, you can pull them up while we talk. I will quickly read through case study number 1, and then we will get started with Steve. Case study number 1 is about Maria Lopez. Maria Lopez is a 32-year-old mother of 3 teenagers who is crossing the street on her way home from work just after 2 a.m. She was hit by a pickup leaving the Rowdy Bar and Grill. The pickup was owned by James Beam, who had been playing tequila pong with his best friend Tommy Tipsy at the Rowdy for several hours, leaving only when the bar closed. After he struck Maria, the driver got out, looked at Maria laying in the street, barely conscious, and then got back in the pickup, which fled the scene. A nearby stoplight camera captured the license plate. Maria's injuries were severe, but she was able to identify the driver as Tommy Tipsy from a photo array, and James Beam as the passenger. Tommy was charged with assault in the 2nd degree for recklessly causing serious physical injury to Maria with a dangerous weapon, acting with extreme indifference to human life. As would later turn out, Tommy had 4 prior DUIs, including one in which he hit and seriously injured the occupant of the car that he hit. Maria and her family entered the United States 10 years earlier from Guatemala, but without the required documentation. We'll go ahead and start and turn this panel over to Steve.
All right, thank you. Okay, I'm gonna jump right in. I've only got 14 minutes to do my spiel, so I'm gonna start my timer now, so when it goes off, I'll have 30 seconds left. Okay, number 1 job for an auto accident attorney is always going to be, I need to find coverage. I need to find ways to get Maria taken care of. So Maria calls me. The first thing we tell Maria is that all of her insurance coverage issues and rights are based on statutes, and they're based on insurance policies. For that reason, residency doesn't matter, citizenship doesn't matter, how long they've been in the country doesn't matter. They can be a temporary tourist from Italy. It doesn't matter. Make sure they know that, because they're going to be afraid to call you and ask you about residency issues. It's always this kind of like elephant in the room. Okay, so first we're looking for PIP, that's PIP. I'm gonna share my screen real fast to have you guys look at my little outline, just to follow along. PIP is PIP, what is that? Personal injury protection. Every automobile insurance policy in Oregon carries PIP on it for the household and for the drivers. So the first question we're going to have is, does Maria have her own vehicle? It doesn't say in the story whether she does or not. I'm inferring she doesn't because she's walking home, but she might have a car at home with an insurance policy on it that will have PIP on it. Her daughters are teenagers. They might be driving with a vehicle. They might have auto insurance on that vehicle. There's PIP coverage on that. PIP coverage is really important because it covers medical and lost income, and Maria is going to need both based on how bad this crash was with the drunk driver. She's going to miss time from work, and she's going to get a lot of doctor bills and visits beyond the ER and the ambulance and all that. Generally speaking, PIP will cover up to $15,000 in medical coverage, and it will cover your lost income up to $3,000 a month for 1 year. So every insurance policy in Oregon has this coverage. So our first question is, does Maria have a car? Does she have coverage of her own? And if she does, it'll be covered. She'll be covered in this crash. In the outline, you'll see that she's a pedestrian. She wasn't in her vehicle. Why should her insurance cover her? Auto insurance, when it comes to pedestrians, is almost like health insurance. It goes with your body wherever you go. So if Maria has auto insurance, it's on her like a jacket when she walks around the street and when she gets hit by a car. That's her first level of protection. It's also for family members and household family members specifically. If her daughters have insurance coverage and she lives with them, they'll be covered. Her husband or the dad is not mentioned in the facts pattern. You got to find out if she has a husband out there or a dad. He might drive the car. He might have insurance. She can get PIP through them too. Look for that. Because she's a pedestrian, there's an order of the coverages that are applicable. Her own insurance will be first. After that, if you look at paragraph E, the striking vehicle, in this case driven by Tommy Tipsy, that's the next level of coverage that she's got. It's important to remember that PIP or PIP is no fault coverage. Maria could be as drunk as Tommy was and wandered out into the street. It doesn't matter. She's going to get PIP coverage. So look at the striking vehicle. If it's an Oregon vehicle with an Oregon policy on it, it's got PIP protection. The great part about it is that it adds up, it's cumulative. So she can get both coverages at one time, but the vehicle coverage is excess. So you can't touch that vehicle PIP. You can't get the medical and the wage loss from the vehicle until you make sure you used up all of her own or until you find out that she doesn't have any. But it's there and it's available. That's another $15,000 in medical coverage and probably more income replacement too, but that's a whole different issue. Okay, wage loss issues. This becomes an issue because Maria's working even though she's not documented. It's the worst kept secret that there are people in this country that don't have papers that are working. Whether they use fake social numbers or have no social numbers, they're out there and they're working. Make sure Maria knows, or your clients know, that insurance companies don't really care about residency status. They want to know if you are working or not. And you can prove that in a lot of different ways. You can prove it with pay stubs. You can get a letter from an employer. A lot of my clients are in the house cleaning business or in landscaping. These are cash paying jobs and they don't document payroll very well. For another of non-immigration related reasons, they don't document it that well. So you can get a letter from the boss and the insurance company will call the boss up and say, does this person work for you? How much do they make an hour? Boom, you got your wage loss reimbursement and no questions about whether or not your application for citizenship is pending. So make sure they know that these are contractual rights and statutory rights that they have, and the residency is no part of it. Doesn't matter. The clients are going to think it matters, but it does not. Okay, moving down the screen here. I'm sorry to go fast. We have limited time. Social Security number is a very sensitive issue for a lot of undocumented, especially from Latin America. A lot of them don't have it, and they don't like being asked about it. Insurance companies will ask about it. The reasons that they ask don't matter as much. It has to do with Medicare and Medicare recovery procedures, but they do ask for it. Make sure that the people know they don't have to give that information up. Hopefully your screen popped up with this form and it's highlighted in yellow. This is literally the form from the government website that you're supposed to provide to to auto insurance companies to confirm that you are not a Medicare beneficiary. They will send this form to your clients and they will tell them to give them the social number. You don't have to do that. You follow the form. Are you a member of Medicare? No. You skip that part that has the Medicare info in it. Move away from that. Go to section 2. put in your name and the date and the claim number and sign it, and then you send it back. You don't need to give your social number up. But insurance companies won't use this form. They'll use different ones that look like this form that will make your clients ask for social numbers, and they don't want to give social numbers, and then they don't turn the form in, and then they don't get their insurance coverage benefits. So make sure that they know social numbers are not a requirement to get coverage from auto insurance. Third-party liability issues here. We've only touched on the no-fault benefits for Maria, her PIP coverage availability from her vehicle and the striking vehicle. There's a massive liability claim for Maria, and this is where the DA's office and the civil claim work together. There's a dram shop claim here. Most of you know what that is. Dram shop is basically colloquialism for a claim against the bar or restaurant or establishment social host who should have known the person there was being overserved alcohol and was a danger when they went out the door. In our fact pattern, Tommy Tipsy, they're playing tequila pong. That's a level up from beer pong. I've never played that. I think I would stink at that, but it's interesting. But he's clearly had too much to drink. He clearly should have been served anymore, and they should have known that. You've got an action against this bar. Now, in our fact pattern, it's clear who the bar is, and you can just go online and figure out the owner of the bar, the insurance company, and get your notices out. The notice is important because in the statutes and the materials, but there is a statute that dictates the time period in which you have to give notice to the dram shop, the actual restaurant or the bar. You got to send them a certified letter. You got to give them notice of that stuff. Sometimes you won't know who the bar is. In our fact pattern, it's easy. It's right there in writing. You can look it up. Sometimes you won't know what the bar is or where the restaurant is. There is a statute 135.857 that dictates the kind of discovery you can get, because the DA's office won't give you everything. It's a pending investigation into a crime. They won't give you everything, but you can get some discovery because it's a DUI traffic incident, and that statute will dictate that. And then you can get the information that can help your claim. Sometimes, though, you still won't know who the bar is, right? Because Tommy's not going to admit where he was drinking in a lot of cases, and he's got a Fifth Amendment right to keep that private. So that notice period can be told for a while if you don't know where the bar is. But as a practical matter, as a practitioner, as an attorney, you want to get that info as fast as you can because you're going to want to file that claim against the bar, because in all likelihood, Tommy and his buddy are not going to have insurance to cover the injuries to your client. It's going to be a big case. And a lot of our fighting is always trying to find enough money for these people. So you got a claim against the bar, and the dram shop notifications you have to deal with. The statutes are in my materials, and the notice provisions are in there too. You can get limited discovery. You have an obvious claim against Tommy as well. He's driving drunk, he's negligent, you're going to win that case. The insurance on the vehicle is going to dictate the coverage for Tommy. It doesn't matter whether or not Tommy has insurance. He's driving James's car. James's car is insured. It's got coverage, it's going to cover Tommy. I made a quick little note because I forgot about this. There's an interesting element when he gets out and sees Maria and then he takes off. There's an intent element that might scare some people. Intent is not going to dictate coverage in this case. There's going to be coverage for the liability claim, so don't worry about the intent. Even if he intentionally ran her over, that wouldn't matter for PIP coverage purposes. The medical and the wage loss benefits, those are going to be there regardless of intent. They don't matter. But in this case, the intent wouldn't matter really anyway. So you got a claim against Tommy for negligence. You've probably got a claim against James Beam as well. He probably negligently entrusted his vehicle to Tommy Tipsy. Probably shouldn't let him drive. He was with him when he was drinking all the time. He may have known he had 4 prior DUIs and he was a menace on the roads. So you probably got a claim against James Beam as well. In the inevitable search for additional coverage and additional funding for your client, you might find that Tommy has his own insurance and that James Beam has his own insurance on the vehicle. Those are 2 levels of coverage you get to get. So make sure you look into whether or not Tommy has his own vehicle and his own insurance that will cover in addition to the insurance from James Beam and the insurance on the vehicle as well. So you might get a couple of levels of coverage there. Okay, I'm going to touch on UIM just for a little second. UIM is underinsured motorist coverage. That kicks in for Maria if the tortfeasor and all the other avenues of recovery you've got are not sufficient. There's another fund of compensation money available for Maria if she has her own insurance and if she can qualify for that coverage because the people that caused the mess don't have enough money. Just one more thing to look out for when you handle these cases. I also wanted to make a couple of other notes. It doesn't say in the packet where they live. So I'm assuming they're Oregon residents, and that Oregon insurance law will dictate and that Oregon coverages will be in play. If Maria happens to be a Washington resident, PIP is not as easy. The short version is that it's optional and it's not as good in Oregon and Washington, excuse me. It's much better in Oregon. Every vehicle and every insurance policy in Oregon will have PIP. They have to have it. But in Washington, it's a purely optional coverage and the limits are lower and they're not as good. So make sure she's an Oregon resident, not a Washington resident. There's still going to be an option there. You got to look into it and make sure that everything was done right. But the PIP is not a given if Maria is a Washington resident for her own coverage. The vehicle coverage, again, I'm assuming it's an Oregon vehicle. Every Oregon vehicle will have PIP coverage on it, and that vehicle will cover pedestrians that are run over by people, even if it's the pedestrian's fault. So make sure you find that PIP coverage so you can get it done. How am I doing on time? I think I'm doing okay, Megan. I got 1 minute to go.
Do you want to use that minute, Steve? Or
I feel like I should almost donate the minute to the panel because they've been so patient.
We'll take it.
I don't know if it's in there or not, but my email should be in the materials. If not, anyone who's out there has any questions, please send me an email. I'm happy to help you out. The number one takeaway for this is please make sure your clients know that their residency does not matter. They have insurance rights under the policies in Oregon and under the laws of Oregon that do not depend on any kind of residency stuff. They just got to be able to find the policies.
That's perfect, Steve. If you could unshare your screen. Thank you so much. Everybody who comes into contact with an undocumented, person who is involved in a car crash needs to be really clear that there are attorneys that can handle this despite their undocumented status. These crashes can be devastating for their employment, and the medical bills can be devastating. Thanks, Steve. Next, we're going to pass it over to Rosemary Brewer. Rosemary, from the crime victims assertion standpoint, can you tell us how you would work to protect Maria's rights in this scenario?
Yep, I am trying to get my screen shared. There we go.
It's perfect.
Okay, so I'm going to start out with just an overview of the foundational rights that every victim is entitled to in Oregon. And like Steve said, their immigration status or residency doesn't matter. All victims in Oregon are entitled to these rights. The most important ones to start off with are the foundational rights, because that's going to inform Maria's journey through the criminal justice system. And the two I want to really direct our attention to are the victim's right to a meaningful role in the process and the victim's right to be treated with dignity and respect. So this is the lens through which Maria should be able to view her encounters with the criminal justice system. You know, it doesn't always work that way, but that's what the Oregon Constitution guarantees her. There's a number of constitutional and statutory rights that victims are guaranteed. And again, like Steve said, it doesn't matter whether the victim is a resident or not. These are rights that she is entitled to. A couple to point out here are the victim's right to be noticed, victim's right to notice and to be present at critical stage hearing, the right to be heard at release hearings and sentencings, and the right to be consulted regarding plea negotiations involving violent felonies. Now, some of these rights are automatic, and other rights are ones that Maria would need to assert with the district attorney's office. And that's a good point to kind of stop and see if Maria is getting documentation from the DA's office that she needs to fill out and return, because she may be reluctant to do that, or it may be in a language that she doesn't read or understand. But a victim can assert those rights without actually filling out the forms. You can call the DA's office on her behalf and assert those rights. She can do it verbally, and also she can assert those rights at any time. So ensure that your client is asserting the rights that she is guaranteed. When you're working with a victim who is undocumented, you might have language barriers. And the first thing you need to do is ask your client what language or dialect she's most comfortable using to discuss the case. And Maria is from Guatemala, so you may assume that she speaks Spanish, but Guatemala has about 25 different languages. And if she speaks one of the more uncommon language or an indigenous language, it's going to take you extra time to find an interpreter who can communicate comfortably in that language. So make sure that you are working with your client in the language that is easiest for them to understand and the one that they'll be most likely to understand if you're having complex conversations with them. Particularly conversations about compensation and restitution, you really want to make sure that they understand what you're talking about. And that language barrier is another reason why Oregon, within the last 10 years, has passed ORS 45275, which is the right to a court-appointed interpreter. Victims have a right to an interpreter at any critical stage hearing where they are attempting to assert one of the rights guaranteed to them by the Constitution. So they're entitled to an interpreter even if they're not speaking at that hearing. For example, they have a right to an interpreter at a hearing to set dates, or at settlement conferences. They have a right to an interpreter. So make sure that your client is either able to understand English and is comfortable with these conversations in English, or that you have the appropriate interpreter for them. When your client is undocumented, they may have some concerns about applying for crime victim compensation. It does entail filling out forms and providing documentation to Department of Justice, Oregon Department of Justice. Reassure your client that the only eligibility requirement is to be a victim of a compensable crime that occurred in Oregon. There's no residency requirement. If you're looking at the forms, and the forms are available from either the DA Victim Advocate's Office or on CVC's website, there is a spot on that form for the Social Security number. Social Security number is not required, and in fact, CVC is taking off the Social Security spot from the forms going forward. So if you're working with their website, I think it's already off, and if you're getting a new form from the DA's office, the new forms won't have a spot for Social Security number anymore. So you can reassure your client that that's not a requirement, and it doesn't matter whether they have one or not. Compensation will cover medical and hospital expenses, counseling costs, rehab costs, and lost wages. If your client is getting paid under the table, it can be a little bit more difficult to prove lost wages, but there are ways to do it, and you can work with CVC to try and get compensation for those. Compensation does have a cap. There's a $20,000 cap for medical and counseling costs, and I think the total cap overall is about $45,000 per case. A couple of things to keep in mind: CVC is a payer of last resort. So if there's insurance or workers' comp, CVC will wait until that is paid out, and then they'll pay remaining costs like deductibles, out-of-pocket expenses. You have to apply within a year, and there is a requirement that you cooperate with law enforcement and prosecution to get CVC. There are waivers in certain cases, domestic violence cases, stalking and sexual assault. I think they will waive the cooperation requirement. So to get CVC, you have to fit into these definitions: a victim in a compensable crime. So that's an important thing to stress to your client who may be afraid to try and apply to the state for this compensation. These are the only requirements. And if they are the victim of a crime, they fit into the guidelines for a CVC claim. Restitution is another thing to really talk to your client in depth about, because your client may or may not be insured. If they are not insured, they may have extra costs that you need to keep in mind. Let the district attorney know early on that there's going to be a restitution claim, and then start working with your client to develop a plan to keep track of their expenses and their receipts. You know, walk them through what all of the out-of-the-pocket costs for this crime made them have, and kind of work with them so that they are prepared to present a restitution request to the DA's office. And I think with that, I'm going to turn it over to Sarah.
Great. All right, I'm going to share my screen. So I'm going to be talking about the options, the immigration options that the people in these scenarios might have. So immigration relief for survivors of abuse and serious crime. Hopefully the slides you guys are seeing my slides and they're moving correctly. So from reading scenario 1, it seems like Maria is very likely eligible for something called a U visa. So I'm going to quickly go through the elements of a U visa so folks can spot that if you come across somebody who has been the victim of a crime. They might have some immigration relief. Based on that, I will say, and I'll say it several times throughout, if you come across somebody who's undocumented and has been a victim of a crime, refer them for a full immigration consultation, because there could be lots of things they're eligible for, not just the things that I'm going to talk about today. So the U visa, what is it? So essentially, it's a temporary form of legal status for people who are survivors of serious crimes, who've cooperated with law enforcement and who've suffered as a result of that crime. The purpose, there's 2 purposes: public safety, so to encourage folks in immigrant communities to talk to law enforcement, not to be afraid to talk to them if they're the victim of a crime, to participate in investigations and prosecutions, so people don't just commit crimes with impunity and go free because there's nobody willing to report them or help with the prosecution. And then obviously the humanitarian, which is to help domestic violence survivors and other crime victims with their immigration matters. So the eligibility. So you have to be a victim of a qualifying crime. You have to have information about that crime. You have to be helpful in the investigation and or prosecution of that crime. And there has to be substantial suffering as a result of that crime. And then law enforcement has to certify the fact the person was a victim and that they were helpful, but they're not responsible for certifying the others. I'm going to go through each of these elements. So the criminal activities that are eligible for a U visa are listed here. This is what's in the statute. So the crime that was involved in scenario 1 was felonious assault. So assault in the 2nd degree in Oregon is a felony. So that's right there on the list. But the highlighted ones are the other ones we see most often. But also I want to point out that it is attempt of any of these crimes and also any similar activity. So if there's a crime that is substantially similar to one of the listed crimes, but it's not specifically worded that way, you can argue that it's substantially similar and should be a qualifying crime. Although I will point out that there is some case law about cases like in California where this type of crime would likely be charged as like felony DUI with injury as opposed to a felonious assault. And there are issues with folks getting U visas based on that. So it's helpful that our statute matches, that is being charged matches the felony assault statute. So you have to be helpful. So the victim has been, is being, or will be helpful to law enforcement agency. That helpfulness can come at any point. But if somebody is helpful and then they stop being helpful, the law enforcement agency might not certify that they were helpful. If they're under 16, they don't need to be helpful. Somebody can be helpful on their behalf. And they'll still be eligible for the U visa. So certifying agencies, any federal, state, or local law enforcement agency, that includes prosecutors, judges, police, anybody responsible for detecting, investigating, or prosecuting a qualifying crime. So that includes CPS, although DHS in Oregon chooses not to certify as a policy, but the EEOC and Department of Labor, all of these are agencies and organizations that investigate crimes and can certify on a U visa. The benefits. So the person gets non-immigrant status for up to 4 years. So it's a 4-year non-immigrant visa. The U visa waives a lot of prior immigration or criminal violations that can't be waived in other immigration applications. So that can be really helpful. They get, and once it's approved, they get an employment authorization. So they're authorized to work. They get a valid social security number for the duration of their visa. And then they can also include other family members as derivatives. And then also after 3 years of status with the U visa, they're eligible to apply for lawful permanent residence. And so it's a pathway to a permanent form of status in the US. There can be derivative beneficiaries, as I mentioned. So an adult U visa applicant can include their spouse, as long as it's not the abuser or the perpetrator of the crime. They can include their children. In immigration, children is defined as somebody who is unmarried and under 21 at the time that the application is filed. So that's pretty expansive. And if the person is under 21, the primary person applying, they can include their spouse as long as it's not the abuser. They can also include their parents, again, as long as they're not the abuser, and their siblings who are under 18 at the time of filing. So they can also include their children as well. So if somebody is 20 and is married and has children, they can include all of those folks. Derivatives can be inside or outside of the country. And so folks who have left children in their home country and are here, and then they apply for a U visa, are eligible to then bring those family members into the country. We have, let's see, and we are having an additional training. If anybody's interested in U visas, we just happen to be having our annual training that we provide next Wednesday. And so it's like an introductory training on how to actually do U visas. We walk through like the nuts and bolts of how to do a U visa. And then we will provide, we can provide cases for a person to work on a pro bono basis and provide technical assistance to them, review everything, help them work through the case if they want to gain experience, and help some Catholic Charities clients get U visas. And so the information's on the slides are being provided. So if anybody's interested, you can just email that. I've also provided my information. And so if anybody's interested. And then we do that as part of Catholic Charities rural program, which is Department of Justice Office on Violence Against Women provides us with money to help rural survivors of intimate partner violence, sexual assault, sexual abuse, and stalking. And so any survivor who lives in a rural area of Oregon or where the victimization occurred in a rural area of Oregon, we can provide a free immigration consultation to them. And if they're eligible for one of the forms of relief available to these types of survivors, we can do the case for free. And so we like to just, if you come across somebody, feel free to refer them. And if we can help them, we might be able to help them for free. And then I'll just say there's some other immigration remedies. I'll go through some in the next scenario, but this is sort of a list, and this is not a comprehensive list. But again, I will stress that if you come across somebody, please refer them to a qualified immigration legal service provider, because they could be eligible for one of many of these things or something completely different. And with that, I actually went much faster than I thought I was going to go. So I will.
Yeah, if you can just end your share screen.
Yeah,
there you go.
I'll pass it on.
Yeah, we are right on time, like to the minute. This is very exciting. Thank you all for your thoughts and comments on scenario 1. And I think at this point we'll move into scenario 2. Without any further ado, I'll read it so that we're all on the same page. Case study number 2 is about Nura Khan. Nura Khan is found in the hallway of her apartment building. She's suffering from bruising on her cheekbones and her chin. A neighbor convinces her to go to a hospital to get examined. At the hospital, Nura tells a nurse that she recently ended an intimate relationship with Helen, her wife, as a result of prior assaults, but she can't tell the police that because she has overstayed her visa from Saudi Arabia. Nura also says that tonight Helen had somehow found her way into the gated apartment complex and was waiting for her at her door when she got home. A police investigation revealed that 2 weeks prior, Helen had been trespassed from the property by an officer at Nura's request after a loud verbal argument. Police also located a 911 hang-up call originating from Nura's apartment, where the operator could hear a woman screaming in a different language and another woman screaming in English. Helen is a US citizen, is arrested for assault in the 4th degree domestic violence, and she claimed self-defense. We had some questions for this scenario. What challenges might Nura face as a crime victim in the prosecution of Helen? What challenges might Nura face if she decides to pursue civil remedies? And would anything be different if Helen and Nura were married? Oh, whoops, I added the detail that they were married, and I shouldn't have done that. In the scenario, they were just dating. We're asking some of our presenters to explain the difference, if there's a difference between dating and married. For answers and thoughts on this scenario, I'll start with Sean Rydell to discuss from his perspective, NERA's available civil remedies in this situation. Can you unmute yourself, Sean?
Yes, I can, and I want to make sure this, all right. If you've got the speaker view, someone text me or email me. I'm assuming you just see this and I have the speaker view. This parallel proceedings presentation I'm about to give is actually a smaller part of a much larger proceedings I give on parallel proceedings, because most of my cases, I'll have the criminal case going on, the potential civil case going on, maybe an immigration matter going on, maybe a protective order issue going on, and then maybe a family divorce proceeding going on. And I have to have and represent my client through all of those parallel proceedings or work with another attorney on those parallel proceedings. You know, criminal, civil, protective order, and divorce proceedings is what I notice here. The first thing I'm going to do is I'm going to get that notice of representation filed with the court out to the district attorney's office and to defense counsel. And one of the reasons I want to make sure defense counsel gets it, because in this situation, that means their investigator and the defense counsel can't reach out and try to interview my client, because in the state proceeding, the criminal proceeding, my client is an essential witness, but not necessarily represented and therefore not protected from the opposing counsel, investigator, or opposing counsel contacting them. So I throw in that representation. Also, just because there's a criminal investigation doesn't mean all the evidence is going to be gathered. The depth and breadth of any criminal investigation is largely dependent upon the individual detective and or officer that is assigned to your case. So you're going to want to send a preservation letter to anyone who might have video of the incident. You're going to want to send a preservation letter to the defense counsel. Just because it happened doesn't mean the police are going to seize the cell phone, search the cell phone, seize a computer, search emails. And you're going to want to get that preservation letter out as soon as you can, particularly to social media. And I bring this up with video cameras because of a personal experience I had in an incident that occurred at an intersection where the police got the video cameras from one building, but didn't get it from the other buildings. And I was able to get a preservation letter out, have those saved, because they'll sometimes tape over in 10 days. And then when we did the civil proceeding, I was able to subpoena those videos from the other buildings that law enforcement didn't gather. Now, as to the civil claims individually, of course, you have the battery, the negligent infliction of emotional distress, and intentional infliction of emotional distress. But more importantly, because once, harken back to what Steve talks about, I'm always looking for coverage, is that apartment building, there's some third-party negligence there, as long as you can prove the issues are foreseeable. And here we have plenty of evidence of issues being foreseeable. And there's a couple of cases that talk about premises liability and the foreseeability of the negligent acts or criminal acts of a third party. I put those there for you to look up. Now, when I meet with my client, I want to lay out what a civil procedure is like. And this is a diagram I had written up by an intern, and then we've kind of worked with it. And I email this to my clients, and I give this to my clients. And when I meet with them in person, I have a big whiteboard in my office, and I'll have this, and I might draw a line for each proceeding they have going on and how they intersect. But we're all visual learners, every last one of us. All we do is look at screens all day. And I find this is a really helpful tool for both my English speaking, non-English speaking, and trying to be trauma informed. Most of my clients have suffered some amazing issues of trauma. And this visual learning helps with teaching the trauma informed about what they can expect in the civil process. And what is really helpful is about a year into the process, when they're frustrated about where they are, I could pull this out and point, we're here, this is what we're doing. And I find it's a really effective communication tool, gives them something to go home and gives them a sense of agency and control over the process because they understand it. Continuing on, You don't want to file your civil case while the criminal case is pending. There are prosecutors who will tell you that they will dismiss a criminal case if the civil case is filed because there is immediate cross-examination as to bias, interest, or motive. Whether I agree with that or not is a different discussion for a different time. But if you have to file your civil case while the criminal case is going, you're going to want to stay discovery. In your materials, there's an example of a motion I've used on several occasions and been really lucky with, staying discovery when the criminal case is pending. If you find a typo in that, feel free to email Aaron Olson and complain about that. Last time I gave something out, I had a lot of typos. I got like 30 emails. I am the king of typos, but feel free to email Aaron Olson if you find a typo in that. If the defendant is convicted, you can file a motion for partial summary judgment on the issues of liability. That motion is a little bit more lengthy, and I didn't include it in the handout material. If you find yourself in that situation where you're filing a civil case and your defendant's already been criminally convicted of the act, please email me or call me. I'll send you a couple of the motions I have filed. And once again, I've had a lot of success in having partial summary judgment on the issues of liability when I have a criminal conviction. Regarding intentional torts, I don't want to get too far ahead of it, but all intentional torts carry with it punitive damages. Why do you want to talk about punitive damages? Well, punitive damages allow me to assess during discovery how much money is on the other side. So let's say I don't have coverage, but I have a client, or excuse me, have a defendant with some assets and is wealthy. The value of my client's claim is often determined by how much money is on the other side. That's not something you can normally get in discovery unless you have punitive damages. So when you have an intentional tort, at some point during discovery, you're going to want to amend to punitive damages so you can get their tax returns, you can get their checking account, and you can know actually how much money is on the other side. Once again, that motion's a little lengthy. I didn't include it in the handout material. If you ever find yourself in that position that you want to amend for punitive damages for intentional torts, please email me or call me. I'll provide you with an example of that motion. I've had a lot of success with that. There's some cases there that you might want to be familiar with. Moving on, as another parallel proceedings, and this comes up a lot, is I apply for a sexual assault protective order or family abuse protective order on behalf of my client while the civil case is pending or before we file the civil case. There is a comparison chart that I got off of OregonLawHelp.org. I just want to make sure that I'm not stealing that from them. I want to give them the appropriate citation. It's a great chart to explain the differences between the different protective orders. That's something I often send to my clients when they're thinking about protective orders and why we're choosing one protective order over another, and what they do, and the criteria for those protective orders are really important. I learned it the hard way. I would file for one protective order and it would get bounced because of a certain criteria that I missed, and then I'd have to refile for a different protective order. This is really helpful. When evaluating whether you want to file for a protective order, it can be helpful and hurtful because the defendant can ask for a hearing and then your client has to take the stand, and the criminal defense attorney and or civil defense attorney has a free shot at cross-examining your client when they take the stand. A lot of times you can limit discovery, but when the hearing comes, your client's going to have to take the stand. My rule of thumb, although it's more of a guideline, is if there's an existing no contact order in the criminal case, I don't file the protective order because my client's already protected. The additional protective order is not going to do anything except expose my client to cross-examination. If the DA's office is refusing to prosecute, or for whatever reason there isn't a no contact order, then I weigh the pros and cons with my client, but then I treat it like a trial. I prepare my client, I bring in exhibits, I subpoena witnesses, and you're going to want to give notice to the court because every court around this state sets aside 15 minutes for protective orders. And if you show up with 10 exhibits and 3 witnesses and a PowerPoint presentation and ready to treat it like a trial, they get real mad real fast. So you're going to want to file a notice that you need a day or two for this hearing. And universally, when I give the court advance notice that this is a complicated procedure, I have this many witnesses, and I'm coming for a day or two, they work with me in finding a hearing. But if you show up that day ready to rock and roll with all your witnesses, you're going to get a tongue lashing. And I've experienced that on several occasions. Regarding the divorce proceedings, you want to make immediate contact with the divorce attorney and work with them. An intentional tort, a civil intentional tort is a huge hammer in defense cases and divorce cases. And when I often work with divorce attorneys, I ask them, assess the value of this case independent of my tort that I have. That's the floor of what we're dealing with. And then any money on top of that is for the consideration of the tort. If you do not get in touch with the divorce attorneys, they will sign a divorce decree and a release that includes any and all claims known or unknown. So you want to make sure they know you're around. You want to make sure they know you can help them and that there's a value above the divorce settlement that you bring to the table. Continuing on, when you're dealing with parallel proceedings, both in the criminal arena, you've got to be very careful of the ethical issues when there's a pending criminal case or a potential criminal case. And this is particularly true and comes up a lot during the settlement conference discussions. When there is a judicial settlement conference in a criminal proceeding, I ask to be present, or sometimes I just show up to be there on behalf of my client. But very often I'm asking the criminal defense attorney and I'm asking the state, do you want to see if we could set up a global settlement conference? This makes prosecutors very nervous for obvious reasons, because the settlement can have nothing to do with my client's cooperation in the criminal proceeding, and it can have nothing to do about my client's endorsement and or lobbying for a certain plea agreement. So it's important that you have a mediation judge and a settlement conference judge there who understands those ethical considerations, but you can still get the settlement done. And if you want to talk about some of the experiences I've had working with prosecutors and civil and criminal defense attorneys and mediators to have a global resolution, and what we mean by global is that it all happens at the same day, because my settlement can't be tied to what the state does. Once again, feel free to email me and call me, and I can talk to you about some lessons learned and things that have happened that worked well in the past, some mediators that can really help you out in that settlement process. Regarding the criminal proceeding, again, if your client testifies or is going to testify in the criminal proceeding, which most likely they are, you're going to want to do a mock cross-examination. You're going to want to work with them as if you're sending them into trial. And the great thing about that is, unlike if the prosecutor does a mock cross-examination, there's no privilege that attaches there. The criminal defense attorney can ask them all about that mock cross-examination that they have with the prosecutor and, you know, infer that the prosecutor was coaching the witness. I can mock cross-examine my client. I can ask my law partner to cross-examine my client. I can ask a friend to cross-examine my client, and all that is privileged. So the criminal defense attorney can't ask about it. He just knows that they met with their civil lawyer. Now, whether you want to be in the courtroom or not is up to you. I've been present in the courtroom and the criminal defense attorney has made no reference to me being in the room. And then I've been present when the criminal defense attorney said, back there in the room is your civil defense attorney. Aren't you only doing this to get a money settlement? And that's a question you're going to want to prepare your client for, and a discussion you're going to want to have with your client about whether you want to be present in the courtroom or not. Also, if this scenario isn't misdemeanors, but you want to explore the possibility of civil compromise with the opposing criminal defense attorney and civil attorney also, whether there's insurance there or not. I know I just upset every prosecutor in the room, and I apologize for that, but there's an example memo, a bench memo, if you will, that I often give to judges when I have civil compromises over the state's objection, so they understand that they can accept a civil compromise over the state's objection. Once again, if you find typos, feel free to email Aaron Olson. Here's my contact information and a quote from one of my personal heroes, Admiral Stockdale. If you have any questions, if you want any motions I filed, please feel free to contact me. I love helping out other attorneys, and thank you all for showing up. And with that, I'm out. There we go.
Awesome. Thank you so much, Sean. And for those of you that haven't had a chance to look through the materials, the written materials, please do. Sean talked about what he didn't include, but he didn't mention what he did include, which was extensive and extremely helpful. So make sure you take a look through his written materials, all of theirs, but the ones that Sean's included are really practical and helpful. Next, I'm going to invite the perspective of our prosecutor, Kara Brooks. Kara, could you talk to us about your representation of Nura's interests and this case talk about it from the prosecutor's perspective?
Yes. So one of the things that in listening to all of these things, one of the things that popped out at me is how, things like a U visa can have implications on a criminal case that might not be super apparent from the get-go. So I want to talk about something that we as prosecutors do encounter with some regularity, which is so-called kind of U visa defenses, where the argument is made that victims of crimes have motives to fabricate abuse in order to benefit in the form of remaining in the United States by applying for a U visa when they otherwise would not be able to necessarily have that benefit and remain in the country. So I'm going to talk about sort of a prosecutor's discovery obligations when it comes to U visas, victims that have applied for U visas. And I'm also going to talk about how to address this at trial, how to work with your victim to have kind of a trauma-informed approach to this and troubleshoot to make sure your prosecution goes as smoothly as possible. So very quickly, let's see, Sarah already talked a lot about U visas during her presentation. I won't go into specifics other than to say that, as it pertains to scenario 2, certainly Nura would qualify for a U visa. Though Sarah talked about, felonious assault being a qualifying, a crime that would qualify for a U visa, both misdemeanor and felony crimes of domestic violence would qualify. So Nura most certainly would be eligible to apply for a U visa, as would immediate members of her family. So before we get into sort of what to discover and how your discovery obligations are triggered, very briefly, I just want to touch on where a prosecutor's discovery obligations come from. Obviously, this is more helpful most likely to the prosecutors in the room, but I'm hoping this information is helpful to civil attorneys as well as you work with a crime victim who has a pending criminal case as well, in terms of how to prepare them for what to expect. So prosecutor discovery obligations stem from the Due Process Clause of the United States Constitution. The seminal case in this area, which I'm sure many of us are very familiar with, is Brady versus Maryland, which holds that it's a due process violation for prosecutors to withhold evidence that is favorable to the defense, regardless of if that withholding is in bad faith or good faith. There's a number of federal cases on this issue, as well as Oregon case law, and there's also statutory discovery obligations. I won't go into detail about these statutes. There's many of them, but the one that is relevant to this discussion is ORS 135.815, which again imposes a statutory requirement that prosecutors disclose any material or information that exculpates the defendant, negates or mitigates guilt or punishment, or impeaches a state's witness. And that disclosure needs to be made whether or not that material is recorded or in writing, and it needs to be made without delay. It's also an ethical obligation, so beyond your statutory and your constitutional obligations, it's also an ethical obligation. And when I talk about this exculpatory evidence, we often deem it Brady evidence, again, stemming from that Brady versus Maryland case. Brady evidence includes things like convictions of state's witnesses, inconsistent statements of witnesses, and as we're really going to focus on, potential bias, interest, or motive to fabricate, be untruthful of any potential witness. So how does that apply to this context? So looking at scenario 2, what if Nura applies for a U visa? Case law is very clear that essentially, because she's applied for the opportunity to stay in the country, which she otherwise might not have as an option on the ground that she is a victim of domestic abuse, a jury could reasonably infer that she has a bias, interest, or motive to testify that she was abused. Therefore, the fact that she applied for a U visa is discoverable. And not only that, but it allows the defense to question Nura about, why she applied for a U visa, whether she applied for a U visa. So this is something to get in front of as a prosecutor. If you anticipate this coming up, talk to Nura, ask her these questions, make sure you obviously disclose this information and comply with your discovery obligations, but anticipate this coming up. State v. Valle is a case where the prosecutor objected when the defense started to ask these questions on cross-examination. The judge sustained the objection, excluded any evidence about the U visa coming before the jury, and that was reversible error. So what if Nura hasn't applied for a U visa, but a direct family member of hers, let's say her mother, who is not a witness in your case, you do not intend to call this her mother at trial, what if her mother has applied for a U visa? Similarly to the last scenario, the Court of Appeals has again found that this is Brady evidence, even though the mother is not herself a witness. Yet again, that information needs to be disclosed. And yet again, the defense attorney can properly question Nura about her mother's visa application. And again, the reasoning is similar. It could be inferred that Nura herself has an interest in testifying that she was assaulted by Helen because her mother applied for a U visa on the grounds that Nura was assaulted by Helen. Again, the takeaway is disclose, and the takeaway is that the defense gets to question Nura. So again, prepare Nura for this line of questioning, even though it was not her that applied for a U visa. Where things can get really interesting is when your victim or your witness in the case, if Nura hasn't applied for a U visa, but may apply for a U visa. Now, in my experience, I don't necessarily have these conversations with my victim. I don't necessarily say, hey, is this something you're thinking about? But if you're getting ready for trial, this is a conversation you should be having because yet again, the Court of Appeals has held that even the possibility of applying for a U visa can be Brady evidence and is proper cross-examination. In this case, State v. Hernandez, the court gave the defense wide latitude in asking fairly exploratory questions. Well, actually, I'm going to step back. On the trial court level, the defense was not allowed to do this, but the case was reversed. Again, it was reversible error not to allow these questions, but the defense was asking questions like, what is your immigration status? What country do you come from? Have you consulted with an immigration attorney? Are you aware of what a U visa is? Do you want to remain in the country? Are you considering applying for a U visa? And again, reversible error not to allow those types of questions. So again, while this might not be something that you readily talk about with a crime victim, best practice, get in front of this. If you have a crime victim who you believe is undocumented, ask these questions. As a prosecutor, these kind of questions sometimes make me uncomfortable, but it is so much better to have this come out through you and have the ability to anticipate these kind of things coming out in trial and know your witnesses, your victims' answers before it comes out for the first time in front of a jury. So I'm going to circle back to sort of best practices in a second, but I keep talking about disclose, disclose, discover. And so I want to be clear about what I'm talking about when I say that. So it's, in my experience, it's pretty rare that I am in physical possession or control of a U visa application. But if you are in possession of the actual application, that needs to be disclosed. I would very much consider filing a protective order to limit disclosure just to the defense attorney, or I would ask for either an in-camera inspection from a judge or redaction, as these applications can contain pretty sensitive information. So I would not give one out, without protections. But if you're not in possession of the actual application, which is, I think, the more common scenario, but you are nonetheless aware that the application has been made by either your victim, your witness, or your victim or witness's immediate family member, or even, as we talked about, that they're considering applying for a U visa. Even though there's nothing in writing, you don't have the application, you still have to disclose that. That is very much your discovery obligation. You don't have a duty to go looking for the application. You don't have to subpoena it. It's not in your custody and control, but you do have to comply with your discovery obligations by disclosing that the application was made. So I just want to shift back, and we've already talked a little bit about this, but if you anticipate this being a defense at trial, get in front of it. Talk to your victim, prepare them for this. Maybe even if you know that they're working with a civil attorney, talk to their civil attorney about this. You don't want this to come up for the first time on cross-examination and take your victim off guard. And you don't want to be hearing about this for the first time and not know the answers that are going to come out. I would highly recommend anticipating this and asking these questions in your direct examination. I think having questions asked by a prosecutor who hopefully the victim has met with before, is familiar with, is more comfortable for that information to come out through the prosecutor than through a very adversarial cross-examination. And again, it gets in front of potential bad facts for you and allows you to bring that evidence out through your own questioning. And again, if you think this is going to be a major issue, I would also seek a pretrial ruling about the scope of cross-examination and the kinds of things that a defense attorney can get into. Though yes, the defense is going to have latitude to ask questions of your victim. At a certain point, the questions can become cumulative. Certain questions may be unduly prejudicial or inflammatory. Don't have that happen for the first time in the middle of trial. File a motion in limine, or depending on your jurisdiction, some jurisdictions prefer to do these through pretrial, motion hearings, a 104 hearing. Request these pretrial rulings so that you're not, for the first time, having to object to a question, even if it's sustained. The jury still heard it, so you're not having to have that situation come up in the middle of trial. So for me, the takeaway is anticipate this issue. Understand what is and isn't permissible. Don't create reversible error by objecting, but at the same time, set parameters for what is and isn't appropriate. And prepare your victim, work with your victim, make your victim feel comfortable. Those are my takeaways when it comes to situations like this, and I'm happy to answer any questions afterward. And here is my contact information, and that is it for me.
Thanks, Kara. That's so helpful. Appreciate it. We're going to pass it over without any further ado back to Rosemary. Rosemary, will you be able to talk about this scenario involving Nura and Helen from the victim's attorney's perspective?
Yeah, so working with victims of domestic violence, there's different dynamics involved. With a victim of domestic violence, you have to consider safety and housing and family, potential loss of income. When you're working with an undocumented victim, there are additional concerns, including the language barriers that I talked about in Maria's case, cultural issues, immigration status. With those issues, in certain cultures, there may be a lack of family or community support for domestic violence victims. So that's something to keep in mind. Immigration status is also used by abusers to control or to threaten the victim. So these are things that you really need to keep in mind when you're working with somebody who's undocumented, who's also a victim of domestic violence. I would advise, if you have something like this going on, seeing if there's a culturally specific advocacy group in your area. That group could be a resource for support groups for your victim. You also may be able to find an interpreter through that group, and the victim can use that group for safety planning. Another thing to keep in mind is if you have a domestic violence victim who needs to relocate, who needs to find a new place to live, Oregon does have temporary assistance monetary grants for victims of domestic violence. Again, there won't be any questions about their status in the country, but those grants are only available to victims who are pregnant or have children. Some other considerations to keep in mind when you're working with a domestic violence victim who may be undocumented, the rights to consider in these cases, obviously all the rights that I talked about with Maria apply here as well, but victims also have a right to participate in settlement conference, plea hearings, and sentencing hearings. Those are all considered critical stages. And the victim has a right to be present at those proceedings if they're held in open court and the defendant is present or has the right to be present. At the beginning of these proceedings, the prosecuting attorney is supposed to inform the court whether or not the victim has requested notice of these hearings or proceedings and whether or not the victim is present. If you look at the statute, ORS 147.512, there's actually a colloquy that the judge is supposed to go through if the victim isn't present. The judge is supposed to inquire whether or not the victim has requested notice of this proceeding and whether or not the victim wanted to be heard. So I don't know how often that is happening, but that is actually the procedure. That's what's supposed to happen. If the court finds that a victim requested notice and requested to be present at the hearing and isn't there for a plea hearing, the court is supposed to not accept the plea until the victim has the opportunity to be there for it or be heard, unless it's in the best interest of justice for the court to go forward. And I've lost my little arrow. Oh, there it is. Other considerations to keep in mind. Victims have the right to refuse an interview, deposition, discovery request by a criminal defendant. And I think Sean touched on this a little bit. So in cases like this, it's very common for domestic violence victims to have their records subpoenaed by defense attorneys. It's common for defense attorneys to file motions for pretrial discovery for things like medical records and counseling records and education and employment records. This is a good opportunity for a victim's rights attorney to jump in and file a motion opposing those motions. If subpoenas have already issued, you can file motions to quash those subpoenas. Another thing to keep in mind is, and make sure your client is aware, that there's no obligation for a victim to talk to a defense attorney or defense investigator. And so you can let the defense attorney or investigator know that your client has asserted that right not to be contacted. Victims also have the right in Oregon to get out of their lease with no penalty. So if your client is in a lease with their abuser, the victim can terminate a rental agreement with 14 days notice within 90 days of the crime, and also has the right to have their locks changed by the landlord. If you look at the statute on that, or ORS 9453, there's a specific form that victims can use to give to their landlord, and they need to have documentation, which is either a police report or a restraining order, or they can just have an affidavit from an attorney or from an advocate saying that they have been the victims of domestic violence. And there should be no penalty to them for breaking that lease. So what happens if you are going through a case and you have a client in this situation and your client didn't get notice of a proceeding or wasn't heard at a sentencing hearing? That's when you can file a claim of rights violation. You have to file a claim within 30 days of when your client knew or should have known about the violation, and you can request a remedy in the form. Once that's filed, the court can set a hearing or a show cause hearing, and then you go to the hearing and you present your evidence as to why the victim's rights were violated and talk about your requested remedy. The procedure for that is found in ORS 147515. This is my contact information. If you have any questions, if you're looking for templates for motions to quash or motions to oppose pretrial discovery, I'm happy to share those. And I will turn it over to Sarah.
Great. Let me share my screen again. All right. So there was a question in the chat about indirect victims. So I'll just really quickly mention that. It's for a U visa. So a direct victim is the person who is the victim of the crime. Makes sense. An indirect victim is the person who can apply for a U visa for themselves if the victim is incapable, incapacitated, and that can mean like, as you can, some of the crimes associated with U visa are things like murder, manslaughter. So if the victim is no longer living, if they're over 21, their spouse or their child could apply for the U visa based on being an indirect victim, as long as they fulfill all of the other requirements of being a victim of U visa. Or if the direct victim is under 21, their parent or their sibling who's under 18 could be the indirect victim. Where we see this most is when a US citizen is a child of child sex abuse, their parent, if they're undocumented, could be eligible to apply for a U visa based on that. So we always ask, have you or any of your children been a victim of a crime when we're looking for U visa information? So back to scenario 2. That didn't come up in either of the scenarios, so I didn't mention it, but somebody asked. So back to scenario 2, it was already discussed that she's likely eligible for a U visa, so I'm not going to go into that. I will flag that that she is in a same-sex relationship and from a country, Saudi Arabia, that is not accepting of that, and so there's the possibility that she could be eligible for an asylum claim, but there's a lot of other factors that go into that. So again, would need a full consultation to determine if she's even eligible for asylum. And so the U visa question came up, that was answered for scenario 2. So I'm going to focus on the question of, does it make a difference if they are married as opposed to dating? And for immigration purposes, it does. So if they were married as opposed to dating, I believe that she would be, Nora would be eligible for what's called a Violence Against Women Act self-petition. So that is, this petition was created because in immigration, there's sort of an inherent imbalance of power. The way that the family petition system works, if somebody who's a U.S. citizen or a lawful permanent resident applies for a family member who is undocumented, the U.S. citizen or the person with status owns that application, so they can withdraw it at any time. If the relationship doesn't continue, then the immigrant doesn't get status. So they're required to stay married to that person or stay in that relationship with that person. So that was recognized by Congress, and so they created the vow as self-petition, which is essentially a way for somebody to apply for themselves as though their U.S. citizen or lawful permanent resident family member was applying for them. And so it allows for them to literally self-petition as though their family member was doing it. So who qualifies? So if you are the abused spouse of a U.S. citizen or a lawful permanent resident, if you are the spouse of a lawful permanent resident who is not abused, but your child is being abused by that person, even if it's a child from a previous relationship, unrelated to the abuser. If you're the abused child of a U.S. citizen, or you're the parent of an adult U.S. citizen or son or daughter who is abusive to you. Those are the eligible categories, and you have to have that relationship, and the person has to have that specific immigration status. So in order to apply for a vow of self-petition, there has to be battery or extreme cruelty. Battery is what it sounds like. It's physical violence. Extreme cruelty is all the other forms of abuse. So it could be financial, emotional, sexual, all the other kinds of abuse that aren't hitting or physical battery. There have to have the qualifying relationship. So you have to be a spouse, a parent, or a child. There has to be that relationship. The abuser has to have the proper immigration status, which means they have to be a lawful permanent resident or a U.S. citizen. There has to be joint residence, if people show that, good faith marriage if it's based on a spousal relationship, and good moral character. And I always say, let me worry about that last one. It's a really complicated, and I will help them figure out if they have good moral character for immigration purposes. So there are some exceptions to those pretty strict standards. You can still apply for a self-petition up to 2 years after one of these 3 events happen. So the death of a U.S. citizen abuser. So you're not married to a US citizen anymore because they are dead, but up to 2 years after their death, you can apply for a VAWA self-petition. If the marriage is terminated and there's a connection between the termination of the marriage and the abuse, so you get divorced from this US citizen or lawful permanent resident, you still have 2 years to apply. Or if the lawful permanent resident is no longer a lawful permanent resident because they're deported, in part related to this domestic violence, if they report them to the police, they get put in removal proceedings, they get deported, they're no longer a lawful permanent resident, you can still apply. Child victims, a child for immigration, again, is under 21 and unmarried, but for this purposes, up to 25 if the delay is related to the abuse. And if somebody is not legally married because the abuser never divorced their previous spouse, but they were lied to about that, they believe that they were entering a marriage that was legitimate, they can still apply even if they're the victim of a bigamous marriage. Again, refer to qualified immigration advice. So there's documentation required for all of these, but I'll point out that the standard is any credible evidence. And so we usually go through with people like, how do you prove battery or extreme cruelty? And that can be anything from like, restraining orders, police reports, hospital reports, but then often the only documentation that we have of these things is declarations from the victim themselves and from family members and friends. And the same goes for good faith marriage and joint residence. Beyond, a marriage certificate proving that they were intended to be married, that they lived together, a lot of times folks who are undocumented aren't going to be on any of the bills, the mortgage, the lease, whatever. They're sort of intentionally under the radar or being forced to be under the radar by their spouse. And so that's difficult to come up with that sort of documentary evidence, but it's that shouldn't be a barrier because it's, again, any credible evidence, which can include declarations, affidavits from friends, family. So let's see. So the benefits of an approval of VAWA. So there's what's called a prima facie eligibility, which is they review the application initially and just determine, yes, it looks like you're going to be eligible. While we do the full review, they send a prima facie eligibility. In many states, that allows you to get some public benefits. Oregon is not one of those states, but I still like to point it out in case anybody is doing work in other states. If otherwise eligible, they would be able to adjust status to lawful permanent residents by themselves. They wouldn't need their abuser to help apply for them or attend the interview with them. They get to do everything on their own because it's self-petition. Still, children can be included in the parent self-petition. They don't have to do their own. They're sort of derivatives on the application, including children abroad. And then once the application for the self-petition is approved, they get deferred action status, which means that they are generally protected from being placed in removal proceedings. It's not a permanent status. People might be familiar with deferred action for childhood arrivals, or DACA, which is just sort of a temporary status, which means that action is not being taken to remove them from the country. They can't travel on this alone, but it does qualify them for a work authorization, which means that they get a work permit, they can get a social security number, work lawfully. So that's important to a lot of folks. So I like to point out how this is different from a U visa because people tend to conflate them because they usually involve domestic violence. There's no requirement of an intimate familial relationship with the U visa, but the VAWA does require that they have that relationship. For the U visa, there's no requirement that the perpetrator be a US citizen or a lawful permanent resident, but obviously VAWA requires that. And the process for U visa takes much longer. There's a statutory cap on the U visa. There's only 10,000 available per year. There's over 200,000 pending. You can do the math on that, but it's approximately, if somebody were to apply for a U visa now, it's approximately 10 years until they get an answer. But there is a new policy that is allowing for bona fide approvals, which means that they are reviewing the applications, even though there's a cap, and giving them deferred action based on like a bona fide review of their application. So hopefully U visa, at least work permits, temporary work permits based on deferred action will be coming out much faster, as the cap can't be changed unless through an act of Congress. And so that's kind of stuck. But we have been seeing some more quickly people getting work permits based on these applications. But I will say those are people who applied in 2016. We're getting those work permits now. So it's still taking quite a long time. So this is included in the materials, so nonprofit legal service providers who work on immigration cases. And then also I included a list of like a referral list of other attorneys if people have places to refer, because the moral of my presentations has been please refer people with immigration questions to qualified immigration providers. And with that, I will.
All right, well, I have 3 quick announcements. It's 5:25. We still have 5 minutes. So I have 3 quick announcements. The third one is going to be to answer your questions about the CLE credit, because I want you to suffer through the first 2 announcements for people in the audience. The most important announcement that I have is I want you to save the date for April 27th of 2022. That is the date for our in-person Hardy Myers dinner, which is our annual fundraiser. It's our 4th annual Hardy Myers dinner, and there's an award given to an outstanding advocate on behalf of victims, the Hardy Myers Award, and it's a lot of fun. So please save the date. The second announcement is that this CLE was recorded, and we have applied for CLEs, computed CLE credits. Those are
right now, but I got a big breaking exclusive news.
Those are pending. And when we have both the recording ready and when we have confirmation of the CLE credits, we will email everybody who registered for this training with the outcome. So the number and all the things that you need to put on your CLE application. We have, 4 minutes for questions. If you have questions of the presenters, what I'm going to ask you to do is to put your name down in the chat. And I will go ahead and call on you from putting your name in the chat. I'm also having some feedback issues. So if you could keep yourself, if you're an attendee of the conference, if you could keep yourself muted unless I see your name go up in the chat, that would help with the volume issues. So I'll wait for a minute or 2. Oh, I had seen Barbara had asked a question about whether the indirect victim needed to be incapacitated or just a minor. Did you address that, Sarah, in yours?
I was just typing in response in the chat, but I can just say it out loud for everybody.
Go for it.
So generally, you're considered incapacitated by your age as a child. You're not competent as a child, but we know that up to a certain point. So around 16, we started getting pushback saying they need to actually be incapacitated or incompetent to not be expected to participate or not be able to be the primary, if that makes sense. And so the statutory language is under 21, but we've seen pushback if the child is over the age of 16 or older.
Okay. All right. And so I do see a question in the chat from Josh Marquis. Good to see you. Are you able to unmute yourself and ask the question?
Yeah, it's more of a comment. Sean was talking about things that, and he's a very effective lawyer for individual victims, but I would, as someone who was involved in the original victims' rights movement in the 1980s and then in the 90s and then in the O's, this could slip away, and I would strongly recommend against those of you who represent victims putting victims in a potentially adversary position with the prosecutors in things like a settlement conference. I think we can agree that the defense lawyers have absolutely no interest either in the prosecution or in the rights of the victim, and I understand victims want to be compensated, and that's reasonable, but I just wanted to make that point.
Okay. Any questions from anybody in the group? All right. Well, thank you all so much. You'll receive an email in no time with the CLE credit information. A big thank you to our panelists. What an amazing group of attorneys, brilliant attorneys. Thank you so much for your time and effort, and have a great night, everyone. Thank you.